Division 118 deals specifically with the main residence, collectibles and motor vehicles. It's not specifically an exemption in relation to matrimonial breakdowns, and it's available regardless of when or why the assets are transferred. But in most relationship breakdowns, there's going to be a transfer of at least a share of the family home as one of the major assets, and therefore this exemption will come into play. There's a couple of requirements here that we need to be conscious of. One of them is that the asset needs to be owned in personal names by people who are residing in the property. So if our family home is owned in a company or a trust, even if the husband and wife are trustees of the trust, they won't qualify for this exemption, and there'll usually be capital gains tax payable on the transfer. So in order to qualify for what we call the main residence exemption, it needs to be owned personally. They need to have resided at that property the whole time that they've lived there, subject to some deeming provisions. If they temporarily move out and move back in again, they can still, in the right circumstances, access it for that period that they were living elsewhere. But be aware of a trap here. If we're acting for a husband and a wife who have been separated for an extended period of time, then if one of them has gone off and bought a new home in the meantime, be aware of what that might do to our availability of this relief here. So if we have the house which is owned 50-50 by the husband and wife, the two parties separate, the husband moves out and goes and buys another house, and they've been separated for an extended period of time before they actually get around to finalising the divorce or finalising the property settlement, we may have lost access to this exemption on part of that capital gain for the period of time while the husband was living somewhere else, because he was a 50% owner of the house, but he wasn't using it as his main residence for the end of that ownership period.